All right, we are back live with a quorum. And just for the record, we did ask the last R who was leaving the room if it was okay for him anyway to have this conversation with a quorum, but without any of the opposition party here. So I guess the way to look at, I've asked, and they can catch up with online and watch the YouTube video when they return. So please pick up where you were, Carrie.
Sure, thank you. So I was talking about the changing the severe or pervasive standard and how that links to the no rehire clause. So this bill makes both of these changes, and they go together because, as we heard testimony about yesterday, currently employers and employees are, there's an argument that being able to include this no rehire clause is a tool in the negotiation toolbox, and that it's very, very difficult to bring cases to court successfully. And there are multiple prongs that you heard about that has to be shown, that it was severe or pervasive, that the employer knew about it or should have known about it. And I can't remember the third one. But the part of why it's so hard is because all of these are very difficult. But changing the severe or pervasive standard would bring that a little bit more within reach for some of these cases. And so it will likely be a bit easier to bring some of these cases to court, which provides a stronger motivation for employers to settle. And so it's very likely that the whole landscape of negotiation will change under this, because right now we're coming from it with the current standard, and that is coloring how all of these negotiations happen or how all of these settlements happen. And that shaking up the landscape by changing that standard could very well mean that employers are more motivated to pay more to settle cases to avoid them going to court, because they'd be a little bit easier to go to court. So that's just one consideration as we're thinking about that negotiation piece. I will say that in the testimony that you heard about this last biennium, you did hear directly from employees who had been impacted by this. I don't think any employees came in and said, this was a great negotiation tool, I'm glad I had it for myself. What you heard was, this was something I was presented with as a condition of a settlement, and I didn't really feel like I had a choice about it, and I wasn't happy about it. So what we have heard from some larger employers, such as the state, such as people who work for these larger employers, and that it can effectively be a way to say you're not working in Vermont anymore because none of these jobs are available to you. And there's a suggestion on the table of a 3-year kind of cooling off period that would allow people to have this prohibition against rehiring for 3 years, but then after that they could come back and work. And I would say that that doesn't address the fact that we have two different sets of laws about this, that these are prohibited under sexual harassment, but not under other cases. So it doesn't address that inconsistency. It doesn't address the basic idea that people are feeling that they're being punished for bringing forward meritorious claims, and we don't want to discourage people from bringing forward the meritorious claims. And it doesn't address the fact that 3 years to someone, where I am in my career, where I'm starting to think that retirement is actually something that might happen to me. 3 years seems fairly short, but to my 23-year-old son, who is just starting out, 3 years he can't even see to the end of it. And so there's a really big difference, and we can't assume that 3 years is negligible.
Actually can't hear anymore.
About these, I will stop there. I'm happy to take any questions if anyone has any.
Karen, can you hear us?
I can now. Sorry, I lost you for about a minute there.
Okay. Representative Burrows.
Thank you. I just very quickly, I was scribbling down what you were saying, and I heard you say the part about the state of Vermont employer
Yes.
said, but can you repeat what they actually said about?
Well, okay, so they did not testify on this, as I recall, last year, but they did come in and testify in 2018 when we were eliminating this from the sexual harassment settlement cases. And their testimony was that as an employer, it was an important negotiation tool for them to use, basically.
Oh, okay.
I can't characterize it more specifically than that, but you could probably, we weren't recording things on Zoom then, but they probably had some written testimony. Yeah.
Okay, thank you.
Yeah, but they did not
I asked.
testify at all last year, and I don't know that they're scheduled to testify.
Employees?
The state of Vermont, the Vermont Human Resources Department.
No, we haven't.
Yeah, so I think that they may have, I can't speak for them, sorry, I should, but we haven't heard from them.
Yes.
Thank you. Probably should have asked Ms. Yang yesterday while she was in her testimony, but maybe you can answer this. We heard a number of, stories of harassment, very, horrible stories that the things that these women went through. And one of them was like, I don't know, 40 times or something like that. And I was just kind of curious on, of course it's not right, but I was wondering why would somebody want to keep staying at that position, even though they keep getting harassed?
Right. Right, well, that's a great question. Like, why would you stay? Why wouldn't you just leave? So it's kind of most people do just leave. And that each person has to make the decision that's right for them individually. I will say that sort of structurally, it makes it a lot harder to address this problem when so many people just say, I'm just going to leave, because then the behavior continues and never really gets addressed. But then there are other people who they don't want to leave because otherwise they like their job, because maybe there isn't another job like this available to them anywhere nearby. I mean, if you work at a, can't think of a great example, but there are, in a small state, I'm sure we all have ourselves or know people who've had the experience of, I'm looking for a job. I don't really want to commute more than 45 minutes. So this is what's available to me, and I'm going to take what I can find.
Well, the job they're at might have healthcare, but you never know, because there's not a lot of employers offer, if you got a decent healthcare package.
Right.
Yeah.
So there are all kinds of reasons why people might stay and want to have it resolved in a way other than leaving. Yeah.
Thank you.
Can you revisit what you said at the very beginning, that the sexual harassment bill already does this? The sexual harassment statute already does this. So this expands it to I'm always amazed that I know the reason why we didn't include this in this language was because that bill came up late in the session and this element of it was postponed. But I'm just struck by the inequity of having it available and having prohibited do not darken my door. That, but I mean, the struggle has been to pass this bill to get these other pieces.
Yeah.
I'm just struck by that.
That bill was very focused on sexual harassment. It included lots of different elements. This was just one of them. And it was not a good reason to not include everything else in there. But that's just because that's how bills happen sometimes. And there really is no reason why, there's nothing different about sexual harassment settlement agreements than other kinds of harassment settlement agreements that would require this or would call for this. No good reason for them to be different.
I'm not sure this question is for you, but if you want to give it a shot, I'm trying to understand. Page 5 defines harassment as engage in unwelcome conduct based on any one of a number of protected status in a protected class. And then when it goes on to break that out, what particular behaviors, it says the conduct is also, conduct may constitute harassment, whether or not is it is experienced by others outside the protected class. And I'm seeing a little, you're being harassed because you're a member of a protected class. But if it's harassment for someone outside that protected, I guess, maybe I just answered my question. It's saying, but I'm seeing
Yeah, it's not to say that it would be harassment if somebody else, even if somebody else experienced it, is saying it could be. So my harassment of you might be based on your particular status. I may also be doing the same thing to other employees, and I have different reasons for it with them. But it doesn't automatically mean that it's not harassment in this one case. Doesn't mean that it is, it's just, this is more like saying all the things that don't make it not harassment.
so it's sort of negative insurance.
Yes,
Okay,
yeah,
that makes sense to me.
okay. It is a little.
Thank you for that. I read that differently. I read it as a person not of a protected class witnessing harassment that's unreported could report it, but
I'm not clear about the answer to that. I have to ask one of the attorneys who will be speaking
So
with
I
you.
think that's a different piece of it. Because it can be reported by somebody who did not
Right.
experience it.
right.
But this is saying if you're harassed, if I'm harassing you because you're a woman, and I'm also harassing Dennis, that it isn't necessarily, we go with the negatives,
Right.
double negatives. Doesn't mean that it's not harassment of you, just because I'm harassing Dennis as well.
Right, okay.
Did I get that right?
Yeah.
I was just gonna add to it, just to add to that clarification, and it's also if you are harassing a woman and another woman also hears that, they can then also consider that as harassment because they are of that protected class. And I think it goes into all those different variations as it breaks down. We heard testimony.
Yes.
Yes.
Okay, further questions for Carrie at this time? No, thank you for staying with it. We are working through it. See how we get, but thank you for being available and for watching.
Thank you very much.
Thank you. All right, next up we have Karen Stackpole, who is here with us on Zoom. Hi, Karen, and again, Karen testified on elements of this bill last year. So, but Karen, as you've noticed, the language is a little bit different. It's a little bit different structure than H320 and 329 from last year.
Yeah.
And we wanted to make sure you had an opportunity to testify on it. So welcome back.
Thank you very much. I appreciate the opportunity actually to testify. And I do see a lot of differences in this bill. Last time I think I had more problems with it than I do now. But just as a quick introduction to those of you I haven't had the pleasure of meeting, thank you, number one, for your service in our legislature. I know that that's a difficult thing. I will say I'm a labor and employment lawyer. I've been one for about 30 years in DC, Maryland, and especially in the great state of Vermont for the last almost 30 years. And I'm litigated actually on all sides of these issues. I have litigated for plaintiffs. I've litigated for defendants. And most of my work that I spend as most of my time as a lawyer, I spend preventing discrimination by going in-house to companies to teach them how to behave appropriately in the workplace and how to create effective policies so that they can not only respect the law and follow the law, but so that they can create a work environment that people want to come and work in. I also spend a significant amount of time talking to companies about diversity, equity, and inclusion, and talking to them about ways that they can make their workplace more inclusive and that they can create greater pipelines so that they can diversify their workforce, which I think makes it a strength. I think that in terms of education, and some of you have heard me beat this drum before, and I will, I know mandates are not always popular, but there are a lot of states that mandate anti-discrimination training. And for me, that's where I would put my money. If I were to mandate it, I might suggest that employers have opportunities to do that. Specifically, I will say that with regard to this bill, there's a lot of changes in here that I actually very much agree with. I do think that some of the changes, and I'm looking at the markup that was online. So for me, it's 21 pages long on F-103. And so
that's the official version that came out of the Senate. So that's substantially longer than ours. But if you give us section numbers, we'll be able to follow.
Yeah. Okay. So, frankly, if you're looking at, the section 1 in terms of the amendments to the act, I actually agree with those amendments. I do think it makes sense to have harassment included as a specific element. I think it's those of us in the law biz have always kind of understood that, but I think that's not a bad thing. I do think that in going even right down to, let's see, so that would be section 1, those definitions I fully appreciate. If we go down to under retaliation prohibited, I think that we were just talking about the various agreements. This is different language than it was last time. It's a little bit more narrowed. I will say that, as Carrie pointed out, there are lawyers who use these provisions as a negotiating tool with people. I frankly don't use them that much, but some clients, prefer them. I do think they have some value to employers, but I don't have a specific strong position on this. We are already doing this with regard to sexual harassment claims. I do think in Vermont, because we have a lot of smaller employers, it might be a little bit overly broad when it adds parent company, subsidiary, division, affiliate. Might be a little bit broad, but again, I don't have, frankly, a huge objection to that. I do have strong opinions and thoughts about the idea of talking about severe or pervasive, changing, some of the standards and making it clear that here you have in the language, and this is subsection 8J, except for claims alleging a violation of subdivision A7 of this section, an employee shall not be required to demonstrate the existence of another employee or individual to whom the employee's treatment can be compared to establish a violation of this section. This language I don't think is good language, because the current status of the law is that we look at these claims with an objective and a subjective view. And the objective and the subjective view is really so that we avoid a concept of a particular person having certain sensitivities that, and I'm talking about people who may, I don't like this when somebody uses that phrase, and then making that a lawsuit. There was an attempt by the Supreme Court in creating the basic balancing test. The McDonnell Douglas test and Meritorious Savings Bank test, but the McDonnell Douglas test uses both an objective view and a subjective view. Is this offensive to this person? That's the subjective view. We understand that. It also has to be objectively offensive, meaning it violates some basic community standards. And so I think here with this bill, with some of this language, you change some of that in a way that I think is not helpful. Will make a big change actually in the number of cases that may be brought forward by essentially indicating that there's really not an objective view anymore, meaning a community standard view. Does the community as a whole find this to be offensive? And while I realize we don't have a lot of diversity in Vermont in terms of race, national origin, even sexual orientation, and a variety of other personal characteristics, we do have, I think, some community standards that are very positive. We don't want people to be discriminated against based on some of those innate characteristics in the workplace. And we don't see this in the same way that Bohr indicated. I have great respect for Bohr, but I listened to her testimony yesterday. And frankly, most of the cases that she identified as problematic were outside the state of Vermont, had been decided outside the state of Vermont. We do not see Vermont courts here tossing out cases because there's a problem with the comparator, or there's a problem that somebody is being an equal opportunity jerk, making ugly comments about a variety of people. And somebody says, oh, well, it was everybody in the room, so it wasn't just you. We don't see that. And so I feel like this language here is kind of an overcorrection and may in fact create a much lower standard. It will lower the bar to people just coming in and saying, well, that person said it to me. There's my subjective standard is met, check the box. And the objective standard of what the community standards are is not kept. I think the other piece here too, in a similar way, is to say that, and I'm looking at section 3, I think. Section 3 under definitions, the definition that is just above section 4, so it's big section 3. Behavior that a reasonable person with the same protected characteristic would consider to be a petty slight or trivial convenience shall not constitute unlawful harassment or discrimination pursuant to this chapter. I think this language too, that a reasonable person with the same protected characteristic would see as a petty slight. Finding people of same characteristics is not always, easy in the workplace. And I think to have a broader standard and a more objective standard, where again, that community standard is met, makes more sense than essentially saying that the comparator has to be somebody who is of exactly the same type. So if it's, somebody like myself who, a woman who's white, who, whatever sexual orientation, any kind of things like that, you would have to say that person, I have to find somebody exactly like that to use as a comparator instead of having that objective standpoint. I think that's a little bit better to have the objective standpoint. I also think severe or pervasive, the manner in which it has this in here. Carrie was right that the standard has been severe or pervasive. It's not severe and pervasive. And that's long-standing law, but it has to be one of those things. This language says it doesn't have to be either one. And the way that this language reads is doesn't have to be either. I think the better standard is the current standard, which has existed for decades and which Vermont has recognized well for decades, which is severe or pervasive. I'll give you some examples. Severe can be one touching. Somebody comes up, smacks me on the backside, and says, hey, Karen, you're looking really cute, something like that. One of those is enough because that is so severe. And in Vermont, and again, I listened to Bohr talk about different examples, didn't hear a single one in Vermont. And I don't know of any Vermont cases where, 65 acts of, or even 45 or even 10 acts of something is not going to necessarily trigger a concern that is pervasive. right? So it can be one thing that is so severe, and an unlawful touching of a person, 9 times out of 10 is going to be severe enough to create an issue. Or pervasiveness can be, it doesn't have to be something that's big and severe, but if you're constantly picking, using a name or using a characteristic or using a term that relates to a particular characteristic, if you're doing it on a regularized basis, yeah, that can be enough to change the work environment for that person. Every day that person has to come in and handle that one little thing that you're doing. Yeah, that's a good standard. So it's not severe and pervasive. It's severe or pervasive, which is the current and a good standard. Here, this language basically tosses that. And that's my biggest concern, frankly, with the bill, is that it appears to get rid of the need to demonstrate severe or pervasive. Sexual harassment need not be severe or pervasive in order to be unlawful pursuant to this subchapter. And that's above 16 in section 2. And that one, I think, is too much, because I think you toss out a standard that has been in place for decades, that is well understood by most Vermont employers, in my estimation. And I think it will make it such that people may have more trivial views of something, or some person may have a particular sensitivity, and it's going to open the floodgates. I have talked to some plaintiffs' lawyers who have said, oh, this is going to make it, this is going to make it a field day for us. And, I think this is going to have a significant impact on the courts in terms of number of claims that are filed. I think it'll have a significant impact on the AG's office, Civil Rights Unit, which also accepts those. And I think, I don't think that's necessarily good. So like I said, there are a lot of things in here that I actually think you did a good job of improving from last time. I really do. It's this severe or pervasive section that I have the biggest issue with, and the lack of the necessity to show either of those, and limiting the comparators to somebody of just that particular type. I also think that is a difficult thing functionally to do with Vermont employers. We don't have a lot of diversity. I wish we did in Vermont employers. And I think finding that person who is the same as the person who's complaining to make a comparator, it's going to be near impossible. And what that means is it's going to be near impossible for an employer to defend these claims. So I do actually also think that this should go to the Committee on Judiciary, because I do think it will have a significant impact to courts that are already, we're already experiencing 4 to 5 year delays on civil trials. So those are my thoughts. I thank you very much for the opportunity. I have a great deal of respect for, the sponsors of this bill, and Bor Yang, Susanna Davis, who spoke, Carrie, all the folks that have supported it. Lots of great respect for them, and have worked hard with them to do training against discrimination to make sure these things don't happen. But thought I needed to bring these thoughts to you about this bill. Thank you.
Thank you, Karen. Questions? Representative Bartlett?
Thank you, Chair. So looking at, I think we were talking about section 3, right above 16, as you had said. If you were to define severe, would you say that any sort of action or something that is said that has a greater effect on the workplace would be considered severe?
So to be frank, the way that courts usually look at these things really depend on the circumstances. And I don't think that's a bad view, because in some workplaces, something may not seem severe as in other workplaces based on the nature of the workplace. And also individuals may not think something is severe. I mean, I grew up with brothers, so the way that my brothers the way that my brothers talked to me and handled me may not bother me that much. but that's why I think it's important to have the subjective and objective view, because subjectively, I may not think it's that big a deal to be called certain names, but objectively, there may be a community standard where, hey, those words should not be used. So I don't think that I think the current standard of having courts look at what is severe, what is so severe. And generally what courts look at is, how does this impact you? Was there violence involved? Did this prevent you from performing any functionalities? Did you miss time for this? Those are all the kinds of elements that the court will look at and the type of evidence the court will look at to see if it's severe. Are they fighting words? Are they meaning I'm going to kill you? One of those is going to be severe enough, right? Physical touching, one of those is going to be severe enough in most cases for courts. So I think rather than have a definition of severe, I think having the courts over time be able to identify things, because courts will recognize things that may not have been recognized 3 years ago because our community standards have changed. Hey, it's not okay to put your hands on me, right? Whereas in the past that might have been okay. So I think the courts to have some flexibility to make those determinations rather than to have a legislative definition that might be insufficient is a better idea.
Thank you.
Thank you.
Further questions for Karen at this time? All right, Karen has, Representative Bartley, part two.
I'm sorry. I like a majority of this bill. In my other life, I'm an HR professional, and I have heard concerns and share several of your concerns. But some of the concerns I'm hearing is that those who are HR professionals are concerned that this language in this bill will take away their ability to have progressive discipline. Somebody may do something or say something that there are times that employees do or act a certain way that they don't realize is discriminatory. And there's a concern that, supervisors or HR professionals will lose the ability to say, okay, let's sit down. I'm going to offer training or how are we going to address this in-house first, rather than going to the courts first.
Yeah. While I think that that may not be the intent and may not be the explicit language, I share your concern, because I think what this says is that something that may be literally is not severe or pervasive, i.e. something that just gets my goat. I don't like it. Now suddenly I can sue you about that. And so the employer in a defensive mode may say, well, if anybody comes to me and complains about Karen, Karen's fired. Or if anybody comes and complains that, Johnny is making them uncomfortable, I may not have the opportunity to address that with Johnny because this person could sue. So what I'm going to do now is I'm going to promptly investigate it. If Johnny said that, I'm going to, just send Johnny out. So that is a fair thought process. I think that HR people have a concern that I better react dramatically, because even something that is not considered severe or pervasive could be unlawful. And I also think, frankly, that this may change some of the insurance products that employers use. Employers often have employee practices liability insurance, what we would call EPL insurance, which covers these kinds of claims. The cost of those claims may go up significantly because the standard here is going to go down. And that may force employers to say, wow, we don't want that insurance to go up. So we're going to, instead of, doing any sort of re-education or reparative justice, even some employers are using reparative justice and trying to, or those kinds of principles, and trying to potentially mediate and educate people. But they may say, if I do that, I'm still liable. I'm still going to get a claim on this, and that's going to cost me in time, energy, money, and my insurance premiums too. So it's a fair point that you raise.
Thank you. I really appreciate it, Karen.
Sure.
Senator Burrows, just attention.
Thank you. This is actually more for Representative Bartley, is that all right? Or for both of you, wouldn't that be addressed in the requirement that the behavior has not been addressed by the employer?
That's a great question. I think,
I mean, that's one of the legs of whatever table or stool is.
I definitely understand that. In my roles, unfortunately, when the idea of litigation is thrown out or on the table very quickly, I think that employers are less likely to act. I think they'll just instantly say, and one of my concerns is you have somebody who does say something or does something wrong, them not realizing the severity of what they are saying. I think we all probably know a jokester who sometimes just needs, hey, you cannot say that. And I think the concerns that I've been hearing is that, yes, an employer has to know about it, but that an employer might be less likely to be constructive or treat also the individual who is a bad actor fairly as well, if that makes sense. And I don't know if that answered your question.
I understand what you're saying, but I don't, neither one of us knows whether that is what would happen or not. I mean,
Absolutely. And I wanted to make sure that I brought up the concern that other people have come to me and said, can you explain this, Bill? And I haven't been able to, because it is a concern that I, as somebody who has been in the HR profession, would say, okay, well, I want to make sure that we can address it like that.
I mean, one could also say that there's a possibility that the employer might be more inclined to take those progressive measures that you're talking about because one of the requirements is addressing it. Now the employer knows that it has to be addressed, and they might be more inclined to take those intermediate.
Absolutely. I think also another concern is if an employer does take those steps and, it's a favorable outcome for everybody involved, what happens if they still get brought to court?
Which definitely does happen. I mean, we certainly will find situations where something may be resolved. An employer can address a particular situation, and over time, either because of changes in personnel or whatever, you're always constantly retraining people, right? So you may have one incumbent who did a wrong thing, gave somebody a bad time based on a personal characteristic and shouldn't have done so. They got corrected for it. That person leaves and somebody else comes in and does the same sort of thing. Right. And so there's a dynamic of turnover with folks. I think it's most important for employers to understand I need to set standards. Managers need to be trained as to what those standards are. I mean, because in Vermont, under the Vermont Fair Employment Practices Act, managers can be held personally liable now by a decision of the Vermont Supreme Court. So employers need to know that managers can be held personally liable. So we do tons of trainings for managers specifically and say, hey, listen, this isn't just about you doing this for the company. Understand that you've got some skin in this game. And so you absolutely need to set a good standard, play to that good standard, and make sure that you're following the law and creating a respectful work environment. So it is possible that by virtue of some of this that employers can still get sued even when they take an action that they believe was geared well enough to make it stop. It may stop for a while and things can reoccur. Each one is considered a new potential cause of action. But I think the concern that's expressed is not something that's unusual.
So, Karen, I know the concern always is litigation, as expensive, time consuming, all of that. My understanding is that the great majority of cases don't get litigated. They get settled or addressed even before going to court, the complaints within the company. And I'm wondering if, so lowering the standard to does not need to be either severe or pervasive. If that really, with most cases not being litigated, it seems like it actually creates more opportunity for things, for harassment claims to be resolved before they reach the point where people are entrenched and want to sue somebody, that they can be nipped in the bud or required to be nipped in the bud now.
Yeah, I mean, I hear what you're saying. I think a claim is a claim, right? So a claim isn't necessarily a lawsuit. So this would allow claims to be made, in my view, based on some of this language, based on things that they just bug me. There's not that objective, subjective standpoint in terms of, and there's not a requirement for it to be severe or pervasive. So even if I'm dealing with those claims internally through a human resources process, that's still taking time, energy, and money. And let me tell you, it's a lot of it because doing an investigation on those kinds of claims may take days. Right. So that's days that a particular person or you hire out to do that. And that in and of itself is very expensive. Our firm does a ton of investigations and they're often in the tens of thousands of dollars because you're talking to, 7 or 8 witnesses. And then you've got to write up a report, explain to management. There's no lawsuit yet, but there's been a claim internally that's been made based on the legal standards. So I think this does open up the opportunity for people to make claims on things that are not severe, that are not pervasive, based on this language, that are going to expand the costs, not necessarily lawsuit costs yet, right? Because I would agree with you that, those do take a while and a lot of those are settled, but I build budgets for those things all the time. And the defense of claims is always in the hundreds of thousands of dollars in the budget, for sure, because they take 3 to 5 years. But even defending something that goes to the Human Rights Commission or that goes to the AG's office or that's just brought by a lawyer sending a demand letter to management. It's not a lawsuit yet, but I made a claim. Those are still in the tens of thousands of dollars. And even an internal claim that's made, it takes time for that person to promptly investigate, which they need to do, promptly investigate it. And if it's true, make it stop. Doing all of that is, generally speaking, something that may take weeks and may take lots of HR and management and employee time and productivity time. So there are costs of time that vary depending on how far somebody takes the matter, but they are significant. And I think it would broaden the range of those claims based on the broadening of this language. But I thank you for the question.
Thank you.
Okay, any further questions for Karen at this time? All right, thank you, Karen. As you may have seen from our agenda, we'll be working on this through the week and I appreciate your comments.
Yeah, thank you very much for the opportunity to testify. I think we live in a great state where we have the opportunity to chat with our legislators directly. And I really appreciate the work that you do. Thank you.
Great, thank you, Karen. Okay, next up, do we have, what's that? We do not. We do not. Okay. We have third witness schedules, who's not here, so let's take an early lunch break.
And
Yes, we're.
Oh, just that I was texted a reminder about the going on in the pavilion. Did people get text about that?